Hey Ray, hope you're doing well. My clients so-and-so just sold their house, and please see attached the agreement of purchase and sale. I have referred the clients to you and their contact information is below. They're waiting for your call. Thanks. This is a typical email that I would get from a realtor, and it means that I now have a potential new client. But for you as the client, do you know what you need to know when it comes to hiring a lawyer to close your deal? When you hire or retain a lawyer, you are essentially securing that lawyer, meaning from now on, that lawyer will exclusively represent you and no one else in regards to your transaction. So for example, if you retain me for the sale of your house and the buyer calls me tomorrow to see if I'm available to represent them, I have to say no because I'm already representing you. In a typical residential purchase here in Toronto, Ontario, one lawyer will normally act for the purchasers and a different lawyer will act for the sellers. In some jurisdictions, you might have one person or one firm acting for everyone. But here, it's one lawyer for each side. There are some exceptions. One exception is if there's a bank providing you a mortgage, then that lawyer will act for both you and the bank. But the bank can always choose to use their own lawyer and in fact might be required to hire their own lawyer in some cases, such as if they are a private lender. In some other cases, such as in a separation or divorce, each of the partners, husband and wife, may have their own separate lawyers. And there are a lot of rules for lawyers in situations like this. They're called the conflicts of interest, but that's for another video. After you've retained a lawyer, you will also need to confirm the scope of their retainer. What exactly will that lawyer do for you and what they will not do for you? In a typical deal for me as a residential real estate lawyer, my scope is limited to just closing the transaction, meaning I will review the title and ownership history of the property. I will verify your identity. I will handle all of the money. I will prepare all of the documentation. And at the end, I will provide a legally binding confirmation to everyone involved that the transfer of ownership has been completed properly. What I will not do is provide advice regarding the physical condition of the property or the zoning or development potential of the property or any environmental issues on the property. There are many other experts for all of these kinds of issues. You should also not expect your real estate lawyer to provide you advice on capital gains or income taxes. You should hire an accountant for that. We also don't do separation agreements. You'll need a family lawyer for that. We don't do joint venture agreements or co-ownership agreements. That's usually done by a corporate or commercial lawyer. Now, some lawyers or firms will do all of the above, but I personally specialize in just closing deals. And that's already a lot of work. So be cautious if you are getting a lot of advice from one lawyer. If you have a lot of different issues, you should really be building out a larger team. Recent trend I've noticed is that the client's parents are asking me to draft an agreement to protect their down payment that they have gifted to their children for the house. Again, I wouldn't want to include that in my scope of work because at this point, that is more of a commercial issue and a potential conflict of interest as well. So your parents really need to hire their own lawyer because they have essentially agreed to act as a private lender in this case. A lot of real estate lawyers also don't advise on residential landlord and tenant issues. This is a bit sad because there are a lot of issues and they are quite serious, such as evictions and poor maintenance, but the legal fees usually outweigh the value of these cases. So as you can see, for most residential real estate retainers, it's a very restricted or limited scope of work. And that is why most residential real estate lawyers, we don't bill by the hour. We charge on a fixed price basis. So this brings us to a somewhat controversial issue, which is the legal fee that we charge versus disbursements. If you decide to shop around for a lawyer, you will come across the term disbursements. Most lawyers will charge a legal fee plus disbursements. And theoretically, disbursements are expenses charged to the lawyer by third parties. For example, taxes and fees charged by the government for registering the transfer of ownership is a disbursement. The title insurance premium charged by the insurance company is a disbursement. But sometimes you'll also see things like photocopying, couriers, software charges, conveyancer fees, all categorized as disbursements. So it can get a little bit confusing and even misleading as to what exactly you are paying for. And sometimes that's the point. It's very similar to how airfares and hotel rooms used to be priced. There were always additional charges at the very end, right before checkout. A lot of times these additional charges were not actually charges, but just ways to charge more for the same product or service. There are a lot of industries like this, but a lot of them are now being forced to change. But this doesn't seem to be happening with law firms. But it might if more clients choose to become better informed. So what do you need to know when hiring a lawyer? First, confirm in writing that your lawyer is working for you exclusively. It's called a retainer letter or engagement letter. And if you don't receive one up front, ask for it, then read it. Also confirm the scope of work. If you have specific intentions for the property, such as tearing it down or renting it out, you want to discuss these with your lawyer ahead of time before hiring them. And then, of course, confirm their legal fee, including disbursements. And then just sit back and let your lawyer go to work for you. I'm Raymond Diep, and this was episode 3 of The Deep Dive with Deep Law. Thanks for watching.